But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
What I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that.
So you are consenting to this court's jurisdiction?
At this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
The property manager, who is also a realtor, and I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager, who was in correspondence with my realtor and lender, is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so, anyway, long story short, I had not looked for alternate living. I had not, I wasn't intending to seek alternate arrangements to move out because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Response.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original is conditional order of dismissal.
Correct.
Was put into place with contemplation of a sale?
That's correct.
No, Your Honor. That is not the case. Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody well, let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was a, after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that were.
Text messages, Your Honor?
Yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff's side, Your Honor, there is a realtor who's the property manager who had asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. Let's call it and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at. there's someone on the plaintiff's side that is talking to somebody on the defendant side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, well, between the person that's a realtor on the plaintiff's side and a realtor on the defendant side.
So the person who's a realtor on the plaintiff side has no agreement to sell the home. There's no.
I get the fact that there may not be some agreement between plaintiff and this person.
Okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They helped,
vis-a-vis the property.
they helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property.
Okay. Okay.
Yeah.
If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what
This other person being whom?
the person's name is Kirk Glassel.
And that's the person that now you're saying is nothing regarding this property.
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson and I were.
Close up and no, go ahead.
Yeah, this email that we were both a party to verifies what that discussion was and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor, in the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual in particular, and then
This person who now is being claimed to be nothing.
Yep,
exactly.
that's.
I do have other.
Well, okay, hold on, folks. This may make sense to you. It doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then right, but is okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there certainly is the potential for some confusion regarding that. And I think that's part of my
I do have more recent communication as of yesterday with the same person,
With who?
with that same realtor, and yeah, and my realtor and the lender.
And the lender?
That's
So if Your Honor, if I
Go
can
ahead.
clarify, I have an email right here between all parties, just clarifying what has happened in an email. And the email includes her realtor, this email chain includes an email from
Okay.
her realtor, back and forth. I believe it's relevant.
Okay, but Mr. Mukherjee, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on.
Right.
If she hasn't misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor. And what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he.
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right, I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That
The
go ahead.
realtor who may, or the realtor who's standing on the plaintiff's side had no, I don't believe had any communications with the lender for Ms. Stevens.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone call or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that would,
Okay. Okay, that's my concern. It may very well be, Mr. McCurdy, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
Ms. Stevens has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know, Your Honor. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable. But I don't believe the writ should be overturned.
Yeah. Evidentiary hearing. I don't know when I can do it. When did we set the current?
August 11th.
Okay. Afternoon.
Yeah, so.
Okay.
Yeah. Yeah, it was already at 1 p.m.
Got it. I understand. Um, the problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
Right, but I don't,
okay.
I hear you, but if you had from the plaintiff side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go, or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired, because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me, doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing, right? But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and imprudent on this court's part to to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Why?
They're written on that signs.
No, I'm going to give it to Lee. Why are you up here? Here.
You don't put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff.
Ooh.
Defendant.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, John.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No,
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Oh, yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Yeah, go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is-
need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
Okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you,
Okay.
Your Honor.
Thank you. Take that,
I know,
and
you didn't write anything.
we'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute.
Inside, it's the couch. Sleep on better. The son's room, my room, it was the roommate's room, hall. Then it also had the laundry room and a bathroom. And downstairs were the kitchen. And the basement, which Lori had eventually converted into another bedroom. Or another room.
Your Honor, permission to approach the witness with what's been marked as People's Proposed Exhibit 1.
No objection, Your Honor.
All right, yes.
I've shown it to defense counsel. Sir, I've placed in front of you what's been marked People's Proposed Exhibit 1. What do you recognize that to be?
Looks like the second lease that we signed.
And is this the one that was applicable at the time of this incident, November the 16th, 2024?
Yes.
Have you had a chance to review that earlier this morning?
Mhm.
Is that a yes?
Yes, sorry.
Is this a fair and accurate copy of your lease?
Yes.
Move for the admission of 1.
Any objection or what here?
No objection, Your Honor.
All right, Exhibit 1 is admitted.
Permission to publish to the court?
Yes.
Can you go ahead and pass that up to Judge Simpson? He's going to take a look at that.
Thank you, sir.
So on November 16, 2024, after you had texted the group chat about needing to get your laundry done, did you ever see Miss Anderson?
No, all I kept hearing was the laundry machine going off.
Okay, so what laundry machines were there in this house that you recall?
There was two laundry machines. It was the washer and the dryer in the laundry room.
What time do you remember doing your laundry?
I must just try starting around 9 o'clock, 10 o'clock.
9 or 10 o'clock at night? All right.
Yeah, I wasn't able to do my laundry throughout the whole day because the son had kept his laundry in the laundry machine all day.
When you say the son, whose son is that?
Florida's son.
Now, as you heard your laundry machines going off, what did you do?
I was hanging out in my bed waiting because I needed to do my laundry for work tomorrow. I kept hearing them go off. It wasn't like immediate, like, oh, stop. It was like, oh, they're not going on anymore. So I get up, go in, turn them back on, and then I'd go and text and I'd say, can't I probably go back on my text, look at them. What I said was, hey, I need to do my laundry for work tomorrow. There was laundry stuck in here all day. It needs to get done.
Were the laundry facilities shared from everybody in the house?
Yeah.
When you went back in to check on your laundry, did you ever see anyone else in that room?
No, it seems like whoever was turning out, whether it was their son or Lori, it seemed they kept doing it as soon as I left. I turned it back on.
At some time later that evening, did you ever see anyone else in that room?
It was only after maybe the third or second time that I had turned it back on. I eventually just stayed in that room because I felt like I had to guard my laundry.
What happened next?
What happened after that was eventually Lori had come in and saying that it was too loud and we don't do laundry after this time. And that it was time, we're not doing this anymore. She turned it off. And things just started escalating from there. I tried explaining that laundry stuck in the machine all day and that I had to do my laundry for work tomorrow.
At any time, did she ever start handling your clothes?
Yes,
What happened?
that's when I brought up my phone and started recording. That's when I started telling her, this is my property, these are my clothes, you're not allowed to be touching my stuff.
What happened after you started recording?
She just kept going. It didn't matter. She just started doing what she was doing. She didn't care about anything. She just said I started needing to get out of her house, that I'm done, that it doesn't matter. And then just things started escalating. She started grabbing my stuff. And then she wanted to get out of the room, started turning off the light on.
Okay, let's slow down.
Sorry.
It's okay. Let's just slow down, take it one question at a time. So when you said you started recording, is that right? Is that a yes?
Yes.
Have you had a chance to review one of your recordings this morning?
Yes.
And was it a fair and accurate copy of the recording that you made that day? Okay. Your Honor, I'm gonna move to the admission of Peoples 2, which is video titled IMG, and that's India Mango Golf 4676. This has been disclosed in discovery.
Objection, Your Honor.
All right, you may go ahead.
Thank you. And as always, Your Honor, I'll work on the sound balance, but it can be rather tricky. I'll see if my display settings are recognizing a second monitor. Yes, they are. I will duplicate and that will fix it, I think.
You're not allowed to touch my property. You can't touch my property. It's not. Can you please not touch me? Can you please stop touching me? Can you please stop touching me? No, I can't live here. What the hell? No, you can't do that. How can you do that? Have you sent me an eviction notice? No, you can't do that. You know you can't do that. You have no legal right to do that. If you want to try doing that, let's go for it. Please stop touching me. Please stop. You're grabbing your hand. Okay. She's not grabbing me. Look, I'm gonna keep this light on if you.
Mr. Loscano, what happened after the end of People's Exhibit 2, that video? Maybe, may I rephrase, Your Honor? Excuse me.
Yes.
Mr. Loscano, what happened as that video was ending?
Her son started getting involved.
And did anyone touch you? Who touched? Is that a yes?
Yes, sorry. I know two people entered the room, and I know that it was dark. I know my phone was taken away from me. That's why I stopped recording, and I know I got pushed up against the wall.
And who was the person that pushed you up against the wall? You don't know?
I know that as soon as I started feeling threatened, the lights were up, and I felt myself push against the wall. That's when I said, I had a pepper spray in my pocket. You don't back off with me. I'm going to defend myself. It felt like it was one person. I don't know. That's when the son stepped in as well. But yeah.
Mr. Loscano, did you consent to Miss Anderson grabbing your fingers on the light switch and touching you in that way?
No.
Did you give her permission to do that? At any time during this evening, did you grab her breast?
No.
Did you at any time grab anywhere else on her body?
No.
What happened after this all happened in the laundry room?
After I told him I had pepper spray, whoever was pushing me against the wall backed up. And the son threatened to then kick my ass if I did anything. And then that's when I called my roommate Paul for help.
Did Paul contact the police or did you? Okay. May I have one moment, Your Honor? It's okay.
I think I may have made a note because I believe he didn't want to get one involved. He was too scared about escalating.
Give me just 1 second, sir.
I'm sorry. He said something about he was too, I didn't hear was
Scared?
I object to that being admitted, Your Honor, as characterization as to what somebody else was feeling. Or matter of fact, where is Paul? Paul can testify for himself. Is he here?
Well, I understand that. I don't know that that has much bearing for the court. I mean, the question was who called 911. So I'll overrule your objection, but I can't see it having any consideration for the court.
I understand.
Pass the witness.
All right, cross-examination.
Your Honor, I confess to not being a slave to technology. I asked the court's indulgence.
We are well aware, Mr.
Well, thank you, Judge.
We will do what we can to assist you through that part.
Okay.
You're gonna play something.
Yes, actually.
Oh. All right. I was gonna say you broke it, just to scare him. You're gonna blame me? Okay.
Your staff was so helpful. Well, Your Honor,
Did you need some assistance? It's okay. Did you need some assistance? I don't
she
know.
was so helpful. It was working just fine before.
It looks like, yep, you're connected
did.
to the internet.
Yeah, but why isn't it coming up?
Click here to obtain network access.
Why is it coming up? Amazing. Simply amazing. I'm sorry, what happened?
Oh, okay, so now you should be able to go back to your email, I believe.
The court closes now?
And now refresh your application.
Click on it, right?
Yep. And then once you plug into here, you should be good.
Okay.
Oh, yeah, I'm plugged in.
See, this is why I count on my public servants for help. No, seriously.
It's okay. I charge for her service. We'll send you the bill.
Okay.
Are you going to be seeking the admission of this, or is this the same video?
Judge, this is the this is the same video. Oh, excuse me. I'm sorry. That's another case. Sorry. Apologize. This is the same video, and I apologize to the.
No, it's okay. It's okay.
I don't understand how.
I just want to make. It's the same video as Exhibit 2.
It is.
All right.
It is. Yeah.
Oh, no, you're touching my clothes now. That's not okay. You can't touch my property. You're not allowed to touch my property. So.
It's playing, but it's not on the screen.
Oh, there we go. Okay, now we got it.
Oh, thanks. You can't touch my dog. Please don't stop.
So I'm going to stop the video right there. Is that your voice on the video? And isn't it true that that is your phone that you're making the video with? Is that true?
Yes.
Now, the state had previously admitted People's Exhibit 1. We have the exact same lease. I can ask for it to be marked, Your Honor, if it's necessary.
The exact same?
Exactly.
You're going to question him on this?
Yes.
Okay, I'll just hand that back.
So I don't know if the necessity of me admitting this, unless the court feels I need to. It's the same exhibit.
Same, no, that's fine. If you're gonna, you can question him on Exhibit 1 then.
Okay. Now, that is your signature at the bottom, correct, sir?
Yes.
Now, and look, in terms of house rules, doesn't it say must maintain quiet hours after 9 p.m.? And when you say that some laundry was in the laundry room 9 or 10, you didn't call the police till well after 12 midnight the next day, sir.
Objection, Mr. Form?
Yes. Is that a question?
Well, isn't it true you didn't call the police till well after midnight?
Not sure what exact time I called the police. I don't know what time this was called.
Well, do you remember talking to the police outside on the front porch that morning, sir? Okay. So is it your statement to this court that you don't know if it was well after midnight when you called the police?
The police were probably called to late tonight. Hopefully that.
Okay, I'm not talking about late in the night, I'm talking about after midnight.
Yes, they were called late tonight, so I guess I would call after 9 p.m. quiet hours.
Okay, so when you tell the judge that 9 or 10, some vague time reference there, clothes were in there, this incident didn't happen at 9 or 10. This incident happened after midnight.
Check the police logs and check when the police were called and just after that time.
Okay. So now, isn't it true that where the laundry room is, which is where this video was taken, correct? Okay.
Yes.
The answer, yes. Isn't it true there are at least 4 rooms right on that same floor where this laundry room is?
Yes.
There is your room. Yes. There was a room where the defendant was staying at, correct? Okay. There was a room where John was staying at, correct? And there's a room where Paul was staying at, correct?
Yeah.
Okay. And isn't it true that that laundry room there is within no more than 15 feet of any one of those rooms?
Yeah.
Okay, so they're right on the same floor in close proximity to each other, correct?
Yes.
And there is in fact a door on that laundry room, correct?
Yeah.
All right. So now, when you were in that laundry room, do you remember telling the police you could have gone to an all-night laundry, but you were fearful of doing so because they go through your stuff when you leave?
I remember telling the police that.
Right.
Yes.
Okay. So you knew you had an option, didn't you, sir? You knew you had an option to go to an all-night laundry instead of being in that laundry room after midnight. You knew that, didn't you?
I don't see how this pertains.
Oh, okay. Well, we have a very competent prosecuting attorney that can make those objections, but your job is to answer my questions. Got it?
Yes, but
Okay, no, sir. I asked you a yes or no question with a yes or no answer. You knew you had an option rather than excuse, sir. You had an option.
no.
You could. Can I finish my question?
Sure, I can answer.
You had an. Can I finish my question?
Did he answer the question? He asked if I had an option. I said
Sir,
no.
sir,
I don't have a.
sir. Yes.
Okay.
You will wait for Mr. Mack to finish his question and then answer.
Okay.
Go ahead, Mr. Mack.
You knew, as reflected by what you just stated that you mentioned to the police, that you could have gone to an all-night laundry, but chose not to because, according to you, when you leave, they go through your stuff. Is that correct?
Yes.
Okay. Now, when you say you put out a group chat, a group chat about laundry?
Yes, it's part of it. We have to group text.
Okay, group text. Did you ever present that group text to the prosecutor? Why?
We talked about this group text a lot. Like it's this communication. It's not. Seems like I recorded. I brought it over to every single communication that we brought around. Like I had to show it to you. It's not something I've been trying to hide.
So this group text, now in the group text, was the defendant part of the,
Yes.
okay, can I finish? Was the defendant part of the group text?
Yes.
Did the defendant give you permission to be in the laundry room after 9 p.m. in the group text?
No.
Okay. The answer to my question is yes or no.
Yes.
She did give you permission?
Permission not. There was never permission not being people.
Well, you say there was never permission to not being there either, but there was a lease that said quiet hours after 9 p.m. Okay, correct, sir? Now, in terms of you being in the laundry room, even though you knew you had options, you went to that laundry room armed with mace, did you not?
Yes.
Okay, so you went to a laundry room when you knew you had options, armed with mace, correct?
Yes.
At any point in time, did the defendant ever assault you or threaten you with mace?
No.
So when the video is playing and the clothes are being taken out, the whole nub of this entire situation is she wanted to turn the light switch off for you to be out of a place you had no right to be in the first place. And you want to keep the light switch on. Isn't that just the whole sum of this whole thing?
Object, this is speculation.
I'll sustain that. You'll need to
And
phrase your
compound.
question.
When you were, let's just say, finger tussling with the defendant, what was your goal, sir? When you were finger tussling over a light switch to feel safe?
To maintain my vision, yes.
Okay, so to maintain, so your goal wasn't to keep the light on?
Keep the light on to maintain vision.
Okay, so, but as a means of maintaining the vision, you wanted the light switch kept on, correct? Okay. So isn't it true that when she had turned the light switch on, you turned it off, you turned it back on? I know you got to say yes. I know it's cumbersome, but you got to answer. Correct?
Yes.
And isn't it true that the only contact that you and the defendant had was in the finger dynamic over the light switch?
No, in the video, you can see her grab my arm.
Okay, but when you say grab your arm and pull it away, it's relative to the control of the light switch.
It's more than finger tussling. She puts her hand on my arm.
Yes.
That's an increased aggression.
Okay, well, okay, like I said, that's why we have a judge. He will decide that. So,
You're deciding right now. You said fingers.
Sir, he will ask a question and you'll answer. Understood?
Yeah.
All right. Go ahead, Mr. Mike.
so when the defendant moved your hand away from the light switch, you moved your hand back up to the light switch. Isn't that true?
Yeah.
Why did you do that?
You put the light back on.
Why didn't you just simply leave the room?
Her son and her were standing in the doorway, and I wanted to feel safe with my back against the wall to put the light on.
Okay, now her son, you say her son were standing in the doorway, right?
In the video, I said, hang on.
Oh, okay, no. You said her son was standing in the doorway, correct?
I'm being very journalistic. I apologize, but her son was standing in the hallway. The hallway leads down like this, and not trying to come.
Well,
Like he's a pretty big dude,
Well,
6 something. It's
okay.
like, yeah, he's imposing.
well, but excuse me, sir. When you are facing going out of the washroom, okay, her son's room is to the left, your room is to the right.
Left, right. And so I have to go past him, and then he's standing right there.
Okay, so,
I have to pass by him to get there, and he's standing right there.
Okay.
And these aren't my friends.
okay, so are you telling me, and we're gonna play the rest of this video, are you telling me you couldn't turn right when you got out of that door and go to your room?
I want no obstacles in my way before I went back.
Sir, I'm asking a very simple question. When you're exiting out of the washroom, okay?
Sure.
I'm asking you, isn't it true your room is to the right? You turn right to go to your room.
Not before I see both of their rooms, before both people are standing in the hallway.
Okay, sir, I'm asking you a simple matter of a structure of a house. Is it not true when you go out of the door from the washroom, your room is to the right and the son's room is to the left?
No, you're not. I can draw this out for you.
Okay. So what you're saying is you had to pass by John to get to your room is what you're saying.
It's all the way down the hall.
Okay, so now when you talk about the grabbing of the wrist, okay, after she moved your wrist to stop you from turning the light on again, and you still try to turn the light on, correct? Wasn't there some more like finger dynamic between you and her trying to control the switch?
Yeah, she left from I turned the light on. She came back in the chair.
Okay.
She kept coming back.
Okay, yes, but she wasn't coming back to your room. She come back to a washroom, which you were wrongfully in the first place.
Wrongfully in?
Yes.
Object is the characterization of wrongfully in the room.
I'll sustain that.
Okay, you were there after 9 p.m., correct?
That's just quiet hours. I can't let them in the house.
Okay, sir, please. You were there after 9. Okay. Yeah, okay, you were there after 9 p.m. and you were being quiet?
Yeah, in the video, you hear me being quiet.
No, okay, sir. The washer and dryer weren't on when the video was being recorded, were they?
So it was quiet.
No, but I'm talking about when you're using the washer and dryer.
Close her out. She had taken them out. She didn't have to come back in and turn the light.
Okay. So what you're saying is the washer and dryer were never on at all.
Objection, Your Honor, that mischaracterized.
That's sustained.
Okay, well, are you saying the washer and dryer were on ever?
I never even said that. I'm saying at this point, when she left the room, the washer and dryer were off. She was
Okay.
taking the clothes out and she's like, you know what? Now you're out of the room. I'm gonna shut the lights out.
Yes, okay.
Back in.
Okay, but before that, you were using a washer and dryer, correct?
Yes.
Okay,
Yes, I was never denied that.
okay, okay. And this was after 9 p.m.?
Sure. Yes.
Okay. Now, when you and the defendant were finger maneuvering for control of the light switch, was it ever your intent to harm her? Was it ever your intent to intimidate her? Was it ever your intent to put her in threat of some kind of a physical harm? And you did have contact with her hand, correct?
Yeah.
And you were finger maneuvering against her for control of that switch, correct?
Yeah.
Just one more minute, Your Honor. Just one minute. For this witness,
All right.
I would ask that has the lease been marked as an exhibit and admitted, Your Honor?
Exhibit 1 is the
Yeah.
second lease.
Yes.
That's been marked and admitted. And I don't know if there was a formal motion to admit exhibit 2.
If there wasn't, I intended to, Your Honor, it would be an oversight on my part. I don't think there's any objection from defense counsel, so exhibit 2 should.
Any
also-
objection? Or
No, no.
Okay, exhibit 2 is admitted.
Thank you, Your Honor.
Thank you, Judge. I said, Your Honor, I have no
Further question. All right.
further questions.
Any redirect?
No, Your Honor.
All right, very good. Sir, you may step back. Well, I do have one clarification. Sir, the clothes that were taken out of the dryer, which I guess would have been machined to the right, that was the dryer? Well,
I don't remember if that clothes being taken out were wet or not.
pardon?
I don't know if you're asking if the clothes were wet or not.
Well, I'm asking which machine was that?
Like those were my clothes that she was taking out.
Yes, were they dry or were they wet?
I know those are my clothes.
Okay. I get that. The question becomes, where, was that the dryer they were being taken out of or the washer?
I remember they weren't done. So I remember
Sir.
they're still wet. That's what I remember.
You recall the video, correct?
Yeah,
Okay, in looking at the video, if you come in the door, there's a machine that's to the left and a machine to the right. Is that a yes?
yes,
She is taking clothes out of the machine to the right. Is that correct?
yes.
Okay. My question to you is that the washer or is that the dryer?
Just when based off of working with washers and dryers, I assume that would be the dryer, but I don't remember exactly. So I feel like washers are usually put on top.
Well, I don't.
I don't remember, I'm sorry.
Okay. All right. Okay.
Maybe a follow-up based on the court's questioning.
Any follow-up based upon my,
No, Your Honor.
you may step back.
Your Honor, may this witness be excused?
Any objection?
No objection, Your Honor.
All right, this witness is excused.
Mr. Loscano, could you hand that back to the court? Exhibit 1, please. Oh, I'm sorry. I apologize.
All right, you may step down.
The people rest, Your Honor.
All right, very good. For the defense.
Yes. Your Honor, first of all, I'd like to make a motion for a directed verdict in this matter. I would like to make a motion for a directed verdict. This court knows better than anyone else in the courtroom what the Michigan criminal jury instructions are, which obviously apply to a trier of fact, which is, in this case, Your Honor. There is absolutely nothing here to show anything other than people finger tussling on the control of a light switch. there is no indication here of the defendant trying to harm or threaten. There's no evidence here that she said, look, if you don't leave this room right away, I'm going to kick your blank, blank, blank. There's no balled fist. There's no punch. There's no kick. There's no I've got mace, contrary to what the alleged victim had. There is simply nothing here other than a landlord-tenant issue that is more suited for a civil matter than a criminal matter, Judge. And so even if looking at in the light most favorable to the state, I just don't see how any kind of intent can be induced from two people in a matter of 15 seconds trying to fiddle over a light switch. So that's my first statement, and depending on what the court says, I'll be making an opening statement.
Response.
Your Honor, I do believe that at this point, viewing all the evidence submitted in light most favorable to the people, a reasonable fact finder could conclude that the initial aggressor in the touching was the defendant. And I'll also further state that the defense counsel said there were no evidence of threats. The threat of you're out on the 22nd could be characterized as a threat. That statement about attempting to tell somebody that they can't leave, to leave their house when they're a tenant, that could be characterized as a threat. I'm not saying it is, but I do believe that there's enough evidence here for us to continue going, let the court be the finder of fact in this matter.
Anything else regarding your motion, sir?
No, Your Honor.
All right. With regard to a motion for a directed verdict, in essence, the court does believe that a reasonable fact finder viewing this evidence in light most favorable to the non-moving party, that being the people of the state of Michigan, could conclude that an offense of assault and battery was committed. One thing is that the notion, and it was specifically asked during defense questioning, that the individual, Mr. Toscano, had the right to be where he was. That is clear from the leasing agreement. So he had the right to be where he was. Why, and also specifically, while that may have been the beginning of the assault, there is then the ultimate turning off of the light switch, testimony from Mr. Toscano that he is then put against a wall, certain threats about his residency being said and what was going to happen. He also testified that the defendant's son was in the hallway. So I'm not saying that would maintain itself, because I'll hear all the testimony, but certainly at this juncture, the court would deny the defendant's motion for a directed verdict. The court does believe that a reasonable fact finder could conclude that an assault and battery did take place.
Yes, Your Honor. Your Honor, this time we'd like to make an opening statement.
Go ahead.
Your Honor, in this case, we believe the evidence has shown and will continue to show that the defendant is a landlord. And at the time, the alleged victim was a tenant in the house. The evidence will show that a lease was entered into by both parties with a specific statement of quiet hours after 9 p.m. We believe the evidence has shown and will show that the washroom is on the same exact floor of 4 rooms where people live, and that the door was open from the video that the court has seen, and that the noise from the washer and dryer is something that is a direct breach of the lease in terms of quiet hours. We believe evidence has shown and will show that this was not an incident that occurred in terms of complaining witness being in the wash area before 9 o'clock. It was after midnight when this entire matter revolved. We believe the evidence has shown and will show that the defendant was simply trying to exert a lawful prerogative of hers as the landlord to have quiet hours, not only for her enjoyment, but for the enjoyment and security of the other residents of the home, whom she had a responsibility to maintain quiet hours. The evidence has shown and will show and perhaps, excuse me if I've said this earlier, that the complaining witness knew full well that he had an option. And the evidence will show that he chose deliberately not to exercise the appropriate option in going to an all-night laundromat because he knew that it was improper for him to be there at the laundry room at that time. The evidence will show, Your Honor, that there is a motive that the complaining witness has for bringing forth this false allegation, because what is not caught on the quote unquote videos that were, the evidence will show, has been really tailor-made for
Can we just pause for 1 second? I'm asking if Mr. Loscano can step out in case I do need to recall him in rebuttal.
All right, very good.
Thank you.
Okay, Judge, he's heard part of what I said already, and he was excused already, Judge.
Well, he was excused, but I think during your opening, there may have been something that raised, so
Yes.
he's now been sequestered.
Thank you, Your Honor.
We'll deal with it.
All right. That the evidence, we believe, Your Honor, will show that Mr. Loscano has a motive for bringing forth this false allegation. In his carefully edited videos, there is no video of him touching my client's breasts beforehand. I submit that the evidence will show that that in fact did happen, despite the defendant's, Mr. Loscano's denial. The defendant will testify herself as to the circumstances in the home and what her intent was. So, Your Honor, she will also testify as to contacting the Pittsfield Township Police Department. She will also testify as to mentioning this to a very close friend of hers. So, unfortunately, Officer Olivia Boatwright is not with us, but she was not an officer that was involved in this specific incident, but was someone that the defendant spoke to tangentially afterwards. And in conclusion here, Your Honor, the evidence will show that at no time did the defendant intend any kind of harm, harassment, physical injury, what have you. And the evidence has shown and will show that in terms of any pushing, first of all, the son, John, is not charged with the crime. So, and in terms of some pushing, the evidence has shown that this complaining witness says he doesn't know who pushed him. So how that is proof beyond a reasonable doubt that the defendant pushed him is somewhat stymieing. So, Your Honor, this is what we feel the evidence will show. And at the end of the hearing, Your Honor, we believe there certainly is not enough evidence of proof beyond any reasonable doubt that the defendant is in fact guilty of this matter. And we are ready to call the defendant to the stand at this time.
All right. Ma'am, please come forward and be sworn.
Solemnly swear affirm the testimony you're about to give me the truth, the truth, and nothing but the truth. Yes. Have a seat and say and then spell your name.
Speak up.
My name is Anderson.
All right. Go ahead, counsel.
All right.
You may inquire.
Ms. Anderson, you are the defendant in this matter, correct?
Yes.
Do you know a person with the last name, Mr. Loscano?
Yes.
And have you been sitting in the courtroom while he testified? Is he the individual that you entered into a lease agreement with in approximately August of 2024?
Yes.
The court has gotten its possession the lease agreement, and if the court maybe could let you look at that, appreciate it. Now, do you recognize that lease agreement, Ms. Anderson?
Yes.
And is that your signature at the bottom of it as the landlord?
Yes.
Now, is that Mr. Loscano's signature also as the tenant?
Yes.
Now, referring to House Rules item number 3, could you please read for the court, what does that state?
Must maintain quiet hours after that.
Now, in terms of the layout of this is a home that you were renting rooms in?
Yes.
Okay. Now, would you tell the court, in terms of the laundry room, and you've had an opportunity to see the video, correct? That was played? Okay. In terms of the laundry room, are there any other rooms in the vicinity of that laundry room on the same floor? Could you please tell the judge how that layout is?
My bedroom is across the laundry room, and my son's bedroom is next to the laundry room. And Marco's room is, okay, then we have a bathroom, and then Marco's bedroom is further down the hall, and then Paul's bedroom is even further down the hall, and then Raj is in the basement.
Okay. So in terms of these rooms, how many feet would you say separates a laundry room from these 4 rooms?
For my room, it's 2 feet. For my son's room, it's 0 feet, and it's right next to my son. For Marcos's room, it's probably 10 feet.
I see.
From Paul's room, it's probably 15.
Now, can you please tell the judge relative to the laundry room, what role does the proximity of the laundry room to the other rooms on that floor plays a part in must maintain quiet hours after 9 p.m.?
The laundry machine makes a lot of noise, both the washer and the dryer, and I told Marcos and everyone that the washing machines should be used after 9 o'clock because everyone is going to work, studying interviews. My son was doing interviews for medicine. I was going to work. People were, the household, the whole idea of 9 hours at 8 o'clock was to maintain quiet.
So what is it on the date and time of this incident that drew your attention to Mr. Lascano in the laundry room?
I was sleeping. It seems like it was around midnight. And then I started hearing this. I didn't know.
Okay, ma'am, you've got to talk up.
Yeah.
Maybe it's me.
It was around midnight or after midnight when I heard the laundry machine running and it woke me up.
Okay, now you heard testimony from Mr. Lascano, I believe earlier, saying that at the time the machine, perhaps I'm wrong, but the machine wasn't running at that time or something?
I'm going to object as to mischaracterizing or at least a clarification. We've got several different timeframes here. Somewhere the machine was running and somewhere it wasn't. So I'd like to-
Why don't we clarify what time frame?
Okay, at the midnight hour when, okay.
It heard the noise and it woke me up.
Okay, so was there anybody else in the washroom doing laundry other than Mr. Lascano when you were woke up?
No.
And this wasn't at 9 o'clock. This is this after midnight.
Objection leading.
Sustained.
Now, the rooms that were there, the noise from the machine, was your testimony was loud enough to wake you up?
Yes.
Was anybody else awoken by the machine?
Was anybody else was there?
Awoken by the laundry machines?
I don't know.
Okay.
I woke up.
Okay. Was there a person that was renting by the name of Paul?
Yes.
Okay. To best of your knowledge, was Paul woken up by the machine?
I don't believe so. I don't know. He's 15 feet down, so I didn't see Paul. I don't know if he was woken up or not.
Okay. Okay. So now you've seen the video, and I'd like you to tell the judge, does that video capture everything that happened between you and Mr. Lascano that night? Could you please tell the judge what happened between you and Mr. Lascano before the incident with the light switch and the finger tussling, whatever light switch?
I first turned the machine off and the light off, and I woke up. And I went back to bed, hoping it was the end. And then maybe 5 minutes later,
I heard the machine again, light was on, so I came out of my room. And when I was going into the room, Mr. Lasano grabbed me.
When you say he grabbed you, what part of your body did he grab you on?
He grabbed my arms.
Would like a Kleenex or something, ma'am? I think there's a box, ma'am. I think there's a box of Kleenexes there. Okay. So
Did she need time to compose herself?
do you need a moment, Ms. Anderson? Okay, because you have to compose yourself so the judge can hear you. Okay. So after this incident happened, where you say he touched your breast, what did you do? Okay, okay, ma'am, if we need to take a recess, we'll do that, but the judge has got to be able to hear clearly what you're saying.
I was in shock, I froze.
Okay, what happened after that?
I remember reaching over, turning off the light, and hoping he would just leave and go back to his room. And I went back to my room, and I thought it was the end. I was processing.
Okay. So did there ever come a time when you and he had some kind of a finger contact about the light switch?
Yes.
Okay, just that's a yes or no question, yes or no answer. Did there come a time when that happened?
Yes.
Okay, could you please tell the judge circumstances what led to that happening?
After several times, he would go in and start the laundry machine, turn the light on. It seems like there was a couple of times. I wasn't counting. I would go in and turn, so we back and forth with the light switch. That's what I remember. I don't remember how many times I turned it off and he turned it on. I don't remember how many times that, but it just was constant back and forth, and I was hoping it would just end.
Now, but was there a time when he was finger maneuvering with you for control of the switch?
Yes, he was touching. I mean, I was turning it off and he was turning it on, and it was back and forth with us. And I don't remember how many times, but it seemed like it almost seemed like a game to him. And I was just wanting to go to sleep. Just ended. I didn't want to escalate.
Okay, now when you turn the light switch off, okay, all right, okay, did his hand come in contact with your hand trying to turn the light switch on?
Yes.
Okay. So I want to be sure that this is clear. He touched, at some point in time, touched your hand trying to turn the light switch on. Did you consent and voluntarily say, please touch my hand to turn the light switch on? Okay. Was that touching of your hand to turn the light switch on, was that against your will?
Yes.
Okay. Was that without your consent?
Yes.
Okay. Now, you heard testimony where the complaining witness said someone pushed him, the light was out and somebody pushed him like maybe into a wall or something. Did you hear that testimony?
Yes.
Okay. At any time, did you push Mr. Lascano into a wall?
No, sir.
Okay.
He's bigger than me. I remember.
Okay. Now, in terms of the touching of your breast, at some subsequent point in time, did you have an opportunity to report that to the police?
Yeah. But
Okay, ma'am, just yes or no? Okay. Do you remember the name of the police agency that you have reported that to?
Ms. Boatwright.
Okay, would that be the Pittsfield Township Police?
Yes.
Okay, did you see Miss Officer Boatwright in person? And did you report this incident to her? Okay. Now, in terms of weaponry, at any time, did you have any mace on you, Miss Anderson?
No, I don't have weapons in my house.
Okay. At any time, did you threaten Mr. Lascano with any kind of a weapon?
No, I don't. I don't believe in weapons.
Okay, ma'am. Okay. At any time, were you threatened by Mr. Lascano with mace?
Yes, sir.
Okay, could you please tell the judge what happened then?
It's that once my son woke up from the back and forth, came out, then Mr. Lasano, he said, hey, I got mace, so back off. You know, it was, he said that, and I'm like,
Okay. But you never had any mace?
No.
Okay. Now, after this incident happened with him touching your breast, do you know a person by the name of Ivory Clinton?
yes, sir.
And who is Ivory Clinton?
He's my dear friend. I've known him for over 20 years, and he's like family. I don't have any parents.
Okay. Did you report this incident in terms of the breast situation with Mr. Clinton?
Yes, I told him.
And I'm sorry, when?
Yes, sir. Yes, sir.
And when did you tell him that?
The next morning. The next morning.
Okay. And isn't it true Mr. Clinton was subpoenaed to be here this morning?
Yes, he's been outside.
Okay. All right. Ms. Anderson, why did you wait and didn't report this incident with your breast to the police right away?
I didn't trust police. They were strangers, and if you knew my backstory, I suffered sexual abuse and racial abuse growing up as a child. My own mother threw me away because I was half black.
Okay.
And I had
Okay. So what is it that made you decide to report the matter to the police when you did?
time to process it.
All right.
And I didn't trust white authority because in my childhood, when I reported abuse, no one ever did anything.
Okay. All right. So, Ms. Anderson, in this situation, and this is coming to an end here, ma'am, was it ever your intent to harm or threaten or violate Mr. Lascano in any way? Okay. Tell the judge what was your intent in this entire situation.
I wanted to just have quiet peace in the house and make sure that all the tenants, including myself, were safe. That's what I wanted. I was hoping that he would just stop.
Okay. All right, Ms. Anderson, I have no other questions. Prosecutor may have some questions for you.
Cross-examination.
Thank you, Your Honor.
Ms. Anderson, what day did this happen?
It was in November.
November 16th, sound right?
Yeah.
You were sleeping and it was around midnight when you were woken up by the laundry machine? And you said it makes a lot of noise, right? And you said your son was woken up by all the back and forth between you and Mr. Lascanos, right? But Mr. Lascanos and you, when you were in having your back and forth in the laundry room, that was after the machines were shut off, right?
I believe I had shut the machine off and shut it back on. So we were tussling with the light switch. So I believe, I don't know how it was on.
So you're not sure what woke your son up, right?
I am not 100% sure.
Okay. And your son's room is closer to the laundry room than yours is, correct? And you were living at this house at the time?
Yeah, on again, off again.
On again, off again? And you saw People's Exhibit 1, correct? The video? I'm sorry, People's 2, excuse me. I misspoke. The video we looked at earlier?
Yes.
And you said that the victim was the only person in the laundry room, right?
Yes.
And you said that you turned off the machine and the light, and then the victim grabbed your breast.
No, when I walked in, he caught me by surprise, and that's when he grabbed my breast, when I first walked in, because that was the second time I had walked in and shut it off when he wasn't there. First time I walked in, he was already in his room, and I shut it off and turned off the light. Then I went back to bed. Thought it was okay. Then about 5 minutes later, I heard the machine again. And so I was gonna just go in and turn it off, turn the light off again. And when I walked in, he grabbed my breast and I froze.
And he grabbed your breast because he was standing at the doorway?
He was in the laundry room.
He was in the laundry room. And then grabbed your breast. And you froze.
I'm
just asking, you said on direct you froze. I want to make sure I understand.
It seems like all of my childhood stuff started coming out and I just froze.
But you turned off the machine and turned off the light and went back to your room, right?
I don't.
You don't remember? Okay, fair.
You know, I know I shut off the light. I don't remember if I shut off, I don't think I shut off the laundry machine. I know I shut off the light and went back to my room, and I hope, yeah, I was just in shock. I didn't.
And from the first time that you went in and shut off the machines and the lights till when we see the video we looked at today, that all happened within just a few minutes, right?
I mean, yeah, I mean, there was probably 5 minutes. He turned the machine on. I turned the machine, he went back to his room. I turned the machine off. I went back to my room. And then the second time when I went back in there, I thought I was just going to shut the machine and light off. And he was there and he grabbed it.
And you would agree with me, though, that from the first time that you went in there till the end of the video we watched, that was just a few minutes, right? No, not sure about time. Wasn't counting. So when you went back in again to turn the machine off, that's when you started taking the clothes out in the video?
Yeah, I think I started taking the clothes out. I mean, he had the video, but yeah, I think I started the third time when he turned it on and I went back in. I think I started taking the clothes out.
Okay, so I'm gonna ask you a really, really simple question. Well, the video that we watched, that's the third time that you went in there to shut off the lights and turn off the machines?
These are the third or the fourth.
After, that video happens after he had grabbed your breast, right?
No, he grabbed my breast in the beginning.
So the video we watched.
Before he did any video, that happened.
So let me ask you a question. I think we're saying the same thing, so just listen really closely. The video we watched today in court happened after he grabbed your breast.
Correct.
Okay. And in fact, you went back and forth into that room more than one time on that video that we watched, right?
I think the video showed the lights going on and off a couple of times.
And before the lights go on and off, it shows you going back and forth for some of the laundry, right?
I think I did at least one time.
At least one time. And you told him that he had to leave your house, didn't you?
I said I was, you know, I was gonna give him an eviction notice.
Is that what you said?
Well, that's what I meant.
But what did you say? You said you need to leave my house, right?
Well, I mean, if he doesn't want to abide by the rules of quiet hours after 9, I thought maybe it would be better if he would leave my house.
Man, my question's very simple. Didn't you tell him to get out of your house?
think I may have, yes.
You may have. And didn't you tell him he was going to be out on the 22nd?
I think he had paid, it was a month-to-month lease, and I think he had paid through the 27th. I think.
No, but focus. Didn't you tell him he was going to be out on the 22nd and maybe 27th? It's hard to hear, but you told him that, right?
I was, what date I meant was the date that he had paid through.
So you told him that he had to be out on the 22nd or the 27th, right?
I don't remember the date.
Okay. You would agree with me because it's captured on the video that the first time we see you turn the lights off in that video, Marcos's hand is nowhere near that switch, right?
Yeah.
And then you would agree with me.
Excuse me, can she?
She said, yeah.
She answered the question. So go ahead, Ms. Blondie.
And then you would agree that he turns the lights back on, right?
I don't remember every single step. You're asking me to recall everything. I don't remember. I wasn't taking video. I just remember some key points.
You've had a chance to review that video before today? Is that a yes?
Yes.
Sorry, same thing. Like we just have to have the recording.
But the video didn't capture everything. It didn't capture before and it didn't capture after.
Which is the nature of all videos, right?
Yeah, but it didn't capture me supposedly pushing him or anything like that. It just stopped.
So ma'am, my question is, do you recall that he turns the light back on after you turn it off?
Yes.
And you turn it off again?
Yes.
And he turned it on again?
I'm trying, you're asking, I don't remember everything.
Okay.
You're asking me to say something, I don't remember everything. I remember we were going on and off and on and on. That's all I remember.
And at some point, he had his hand on the light switch holding it on, right?
Yeah, just like I had before that.
And you pulled his fingers away to turn it off?
Yes, but yes. And he had touched me before.
Oh, ma'am, that wasn't, I didn't ask you any questions about that. My question was just about the light switch. Do you recall appearing for court here on February the 5th, 2025?
Yeah.
And do you recall that's the date that this case got set for final settlement conference? Does that sound about right? And is that in fact the day that you went to Pittsfield Township Police Department to talk to Officer Boatwright about your breast being touched? And isn't it true that you told Officer Boatwright that you were discussing the case with your attorney and decided that the updated version of events needed to be reported?
I mentioned it to the lady at the counter and she said, I told her and she said I should go report it.
So on February 2nd of 25 is when you went to Pittsfield and you were able to chat with Officer Olivia Boatwright, correct?
At that point, I had the courage.
What lady at what counter?
And Your Honor, the court asked a question which I was going to ask. I don't understand what is this all about? Who is the lady? Where?
I'm assuming it's about the date that the report, but I'm trying to figure out what lady at what counter.
Here in the court, I was going there asking her why, how I could include some other information, and because no one ever called me, and she told me to go to the Pittsfield Township Police and put the report there. And
It was one of the court clerks that told you that?
Yes, I was telling her that no one called me to I said I had some more information.
Okay, all right.
She told me to go.
You answered my question. Go ahead, Ms. Blondie.
And that was the date that you were able to go to Pittsfield Police Department and make that report?
Yeah, I had.
It's just a yes or no. So that's the day you went, correct? On February 2nd, 2025?
February 2nd or February 5th?
I said this, I meant the 5th. I apologize, Your Honor. I misspoke. I read the 2. I meant February the 5th. Didn't you in fact tell the police officers though, that that your breast was grabbed when you were removing the clothing from the dryer?
Well, excuse me, Your Honor. She's saying tell the police officers. She spoke to one police officer, Officer Boatwright. Who are these officers?
I don't know.
Well, hold on. At what point are you talking about?
I'll rephrase.
All right.
When you went to Pittsfield Township Police Department on February the 5th, and you spoke with Officer Boatwright, isn't it true you told her that this happened while you were removing the clothing from the dryer, this being the touching of your breast?
No,
That's not true. So if that's in a police report or if that's captured on Officer Boatwright's body camera, that's not true?
yeah, I told her I walked in and he grabbed my dress.
All right. So if we are able to get Officer Boatwright here or review her body camera and we find out that that was what you told her, that would not be true.
I told her exactly what happened.
So if it's different than what you're saying now, which one's true?
Well, Your Honor, first of all, she's asking speculation.
Cross-examination, Mr. Mack. I'm going to let the questions go. Go ahead, Ms. Lundy.
Please answer the question, ma'am. My question was, if we review Officer Boatwright's body camera, or we have her testify, and she testifies or her body camera indicates that you told her that your breast was grabbed while you were removing the clothing, right? Would that be true?
I did not tell her I was removing it. I told her we were arguing over laundry machine.
Okay, and if the body camera or the testimony from the officer indicates that you said it happened while you were removing the clothing, that would be different than what you said today, right?
I did not tell her that, so she would be lying.
She would be lying,
Yes.
and her body camera recording would be lying if it captures you saying that.
I did not say, you're putting words in my mouth.
I'm just asking a question. If those two things happen to be, okay.
Ma'am, are you going to answer the question, please?
I told her.
So if Officer Boatwright says something different, she's lying.
Yes.
Your Honor, I was asking-
All right. Well, not really, but okay. We have the answer.
And if the body camera captures you saying that it happened while the clothes are being removed from the dryer.
No. Why are you, I didn't say that.
All right.
May I have a moment, Your Honor?
Yeah.
Nothing further, Your Honor.
Ma'am, what were the hours that constituted the quiet hours?
9 p.m.,
Until when?
9 a.m.
The agreement doesn't say that, though. Is that
Well-
right?
waking hours.
Well, ma'am, the agreement doesn't say that, correct?
Correct.
All right. Because I'm a bit confused about the whole arrangement and disagreement, but is this property registered for rental with Pittsfield Township?
At the time, it wasn't because I was owner occupant, and I was told when you're an owner occupant,
Okay, so that's a no?
no.
All right.
Because I even asked.
Why? Why was it important to you that the light switch be turned off?
Because I was hoping that we would stop doing the laundry, light switch off and the laundry machine off. So when I went in there, I turned the laundry machine off and turned the light switch off.
Okay, but when you went back in, you also turned the light switch off, right?
I mean, I'm paying utilities, so I'm.
Well, no, you're not. According to, look at your lease agreement. Doesn't his rent include utilities?
Yes.
So he's paying utilities.
Yeah, but part of the rules that I put on the refrigerator is everyone she tried to conserve energy and keeping them
Ma'am,
off
why were you turning off the light?
because it was midnight. I thought it should be shut off and everyone should be asleep.
But that agreement doesn't say that though, does it?
I thought it was assumed at 9 p.m. quiet hours. That's what I explained to him when he signed the lease, that it was to be quiet hours. After 9
Ma'am, would he be violating the quiet hours if he had gone into that room, did no laundry, but just stood there with the light on?
No,
So what was the purpose in turning the light off?
just that have him maybe go to just stop doing the laundry.
Okay. So at some point, and you saw the video, you're removing his clothing from the machines, correct?
Yes,
Was that from the dryer?
I believe it was from the washer.
So the clothes were wet?
Yes.
Where did you take those clothes?
To the room.
And when you took them to his room, what did you do with them?
I think there was a laundry basket or something, or maybe I put them on the floor in the room.
Pardon?
I think I put him in his room. I think I recall putting him on the floor, or maybe there's a laundry basket right there by the door.
So you recall the clothes being wet and you put them on the floor?
Yeah, or in a laundry basket. I can't recall if it was the floor or the laundry basket.
Okay. When you walk into that room, is the dryer to the left or to the right of the machines?
Oh, you know what? Now just saying that, I actually pulled them out of the dryer because
Is the dryer to the left or to the right when you walk in the room?
when we walk in, dryer's to the right, so I was pulling out of the dryer, washers to the left.
Okay,
So they were in the dryer and not quite dry.
all right. So what was your purpose in removing the clothing from the dryer?
To have him, observe quiet hours and just not do laundry at midnight.
Okay, so let me ask you this. Once you had accomplished that, had you not then at that point restored, I guess, this quiet hours?
I kept this whole situation when the laundry was, I took the laundry out. Quiet hours were restored, but then when you would go back, if I went back in, it was because the laundry machine, the washer was being used. I don't recall exact details, but it was just either one machine or the other was being used. I don't recall, but I just wanted to go to bed and have it in.
So are you claiming they were clothes in the washer now?
I think there were.
Then why didn't you remove those clothes?
I don't know. I just was trying to get him to stop using the laundry. I wasn't taking notes.
I'm not asking if you're taking notes. I'm saying, why didn't you? You're now saying that there were clothes in the washer.
There were clothes in the washer and in the dryer.
So if it were trying to get him to stop, why did you only remove the clothes from the dryer?
The wash machine was, I believe, was off. And I was just trying to get him to stop. I wasn't thinking, oh, remove him from the washer and dryer.
Ma'am, I'm trying to figure out why you did what you did.
I was just trying to get him to stop, sir. I was just trying to.
And in doing that, I'm also trying to figure out why you removed the clothing from the dryer.
Just trying to get him to stop, sir.
Okay. So once though you had removed the clothing from the dryer, put them in his room, either in a basket or on the floor. At that point, there was no longer noise coming from that room, correct? And when you came back into the room after you removed the items from on top of the dryer and went down the hallway, you came back into the room, right?
I think I tried to turn the light off.
Okay, but if you had turned the washer on, why would you turn the light off?
I thought it was time for everyone to go to bed. I just wanted, that was normally what I would do, is turn the washer off.
Did you turn the washer off?
I believe, I don't want to misstate things, but I believe both the washer and dryer were on at some point, and I don't know what order I turned them off.
Ma'am, at some point when you removed his clothing, did you want to see the video? I'm not trying to trick you. I'm just trying to yes, can we put exhibit back up?
I just do.
Could we play the whole video? Would that be okay?
I don't want to.
I don't care if we play the whole video. That's fine. We can play the whole video.
It's only about 2 minutes long. Judge, I have to interrupt. Can I just have a bathroom break just for a moment? Whenever it's appropriate.
Okay, yes, just momentarily. I don't have many questions, but I'm just trying to figure something out here.
You're touching it close enough. That's not okay. You can't touch my property. You're not allowed to touch my property. No. You can't touch my property.
No, I'm trying to sleep.
You can't touch my property. Please tell me stop it. All the time with your dog.
Those are my towels, the last set of towels.
Okay.
Yeah.
Can you please not touch me? Can you please stop touching me?
Hear that, the
Can you
water
please stop touching
direction.
me?
Okay.
No, okay. No, you can't do that. I don't need that. But have you sent me an eviction notice?
You're out on one side.
No, you can't do that. You can't do that. You have no legal right to do that. If you want to try doing that, let's go to court. Please stop touching me. Please stop. You're grabbing my hand. Okay. She's not grabbing me. Look, I'm gonna keep this light up, right?
Okay, ma'am, you've seen that, you just saw the video. After you just now, not through a question, but you said the items that were on the top were your items.
Yeah. Did you hear the little bell?
Okay, ma'am, yes, I heard the little bell that told me that was the dryer. So, when you took the items that you now say are yours off and are leaving the room, at that point, the washer's not running, is it?
No, but I thought I heard the bell.
Well, ma'am,
Yeah.
the washer's not running, right? And at the point at which the dryer door shuts, and that's when you hear the little bells,
Right.
and you grab the stuff ultimately off the top, the dryer's not running either, is it?
Right.
Okay, so at that point, safely we can assume there's no noise coming from either of those machines.
Right.
When you walk out of the room, then what is your purpose in turning out the light?
I was just thinking that if I turned on the light, he would leave the room and go back to the bed. And not use the washer or the dryer.
But to be clear, the turning off of the light had nothing to do with the quiet out. Is that correct?
Well, in my opinion, it did. But,
Why?
I mean, I know you may, I
This
just thought the lights out.
takes an
quiet
unexpected
hours.
turn as Michael Anthony Thomas Jr. appears
In
before
fact,
the
the
judge
lights are
with
the
his
lighter.
case scheduled for trial and jury selection the following Monday. At first, the defense is prepared to move forward, but there is one important issue that could potentially affect the direction of the case. Thomas's attorney explains that there was recently a hearing connected to the same allegations in a separate family law matter, and testimony from that hearing may contain information about the complainant that could be important to the defense. Rather than rushing straight into trial, the attorney asks for time to obtain and review the transcript from that earlier hearing. The judge agrees that both sides should have the opportunity to examine it carefully. The court decides to reset the case to a review docket, giving the attorneys time to get the transcript and determine whether the testimony changes anything about the case or possible negotiations. The judge also notes that a previous plea offer had already been rejected. That means the newly requested transcript could become especially important. If the information from the family court hearing changes the situation, the attorneys can return to court and discuss whether a different resolution is possible. But if nothing changes, the case will go right back onto the trial docket. For now, Michael Thomas's trial is put on hold while both sides wait for a closer look at the earlier testimony. One transcript could potentially change the strategy of the entire case, or it could simply confirm that the case is headed straight to trial. The next court date may reveal which direction this case will take.